So we're going to start. Good morning, good evening, good afternoon, wherever you're joining us from. Thank you very much for joining our webinar today. So that's the SOAS Arbitration and Dispute Resolution Center webinar. Our topic today is mediating chieftaincy conflicts in Africa. There will be quite a few people who have no clue what chieftaincy is or chiefs are all about, list of all disputes regarding chieftaincies and how this can be resolved on the continent. So just to set a very quick context before our two experts begin to engage with various issues. The first thing to note is that we do have a chat function and a Q&A. If you have questions, please just pop them in there and you can interact. And you can, if you think you're qualified to answer any of the questions, please go for it. And our experts will come back and if they need to make any additional comments, they would do so. My name is Emilia Onyema. I'm a professor here at the School of Law at SOAS, University of London, and I'm the director of the SOAS Arbitration and Dispute Resolution Center. So who are chiefs, or what is chieftaincy all about? So various African communities had their own governance structures pre-independence, which they still retain. So communities have well-respected families, or usually they're men who come from large families, very wealthy families, and they sort of have this chieftaincy process that is usually just made up of people that are very well respected, highly regarded within the community. I'm stressing those two keywords because I know that our speakers would stress those. And the idea with a chieftaincy is quite hierarchical. So you have the chief or the king, or usually a king, not a queen, but sometimes you get a queen. But generally you get the king, and then you have chiefs who are like ministers, who take care of different aspects of the community, who sit with the king in council and effectively govern their communities. That is a very loose and very broad description. But for some of us, some of you might be wondering, what has that got to do with anything modern? It's because those systems sit side by side with the formal governance structures that we find in most African states. And for those of you who advise in foreign investors that have anything to do with any community would need to engage with these governance structures. So they are important. Your foreign investor cannot peaceably exploit their investment if those communities are at war or there's conflict in those communities. And those are the sorts of issues that Nuhu and Elizabeth will be engaging with today and trying to figure out and sort of help us understand how these disputes are resolved. And then they're going to discuss a real case. So they're going to out of Ghana, and that's simply because they're both heavily connected to Ghana. And so they will discuss a case out of Ghana and the ideas they have out of their own research on how such disputes can be resolved. And so who are our speakers today? We have Elizabeth teaches law here at SOAS and at Roehampton. I think that's the university as well. Yeah. And then Nuhu is teaches here at SOAS. He's a lecturer here at SOAS. And that's all for now. If you have questions regarding their background, please put it in the chat and we'll pick up on that. So to start the conversation, I'm going to start with Elizabeth because, ladies first, I guess. So I'm going to start with Elizabeth. And Elizabeth, I was wondering if you would sort of sketch out for us what chieftaincy conflicts we have on the continent, what they are like. And again, why should the investor community be concerned about this?
All right. Thank you very much, Professor Emilia, for the introduction, and hello to everybody listening to us. Right, so Professor Emilia has set the ball rolling. She's talked about the institution of chieftaincy. So I'll just go straight to talk about conflicts. Now, chieftaincy conflicts are not isolated disputes over titles. Most times when we talk about it, that's the first thing which comes to mind, titles. But they often reflect deeper issues of identity, governance, and control over resources. And they are widespread across Africa, and of course, Ghana is not an exception. In 2019, there were over 352 unresolved chieftaincy conflicts in Ghana. As of 2024, which just last year, there were 457 cases of chieftaincy disputes which were being mediated by the National Peace Council. Not all the conflict had been submitted there. So it just gives an idea of what we are dealing with. The main causes of chieftaincy conflicts. Let me just talk about 4 of them. First of all, succession disputes, which would readily understand. The common cause is succession between rival royal houses or factions over who has the legitimate right to occupy a stool or skin arises. And these disagreements or conflicts are fueled by unclear lineage rules, political interference, or contested origin. Another main source of chieftaincy conflicts in Ghana and indeed across Africa is land and resource control. And that's one thing chiefs do. They control the land, they hold the community's property in trust for the community. So, and it's loosely tied to land ownership. As custodians of communal lands, the key word here is custodians, chiefs wield a significant influence. So what happens is that when there are competing claimants or factions who seek to control land allocation, royalties, or access to natural resources, conflicts are bound to erupt. A third cause of chieftaincy conflict is ethnic and identity tensions. And some conflicts have ethnic or sub-ethnic dimensions, especially where there are different groups who claim historical rights to the same territory or stool. The Boko conflict, for example, which we'll be talking about later, it reflects both traditional succession and a broader ethnic identity tension between the Mamprusis and the Kusasis. And the fourth main cause of this chieftaincy conflict is political interference. State actors and, of course, politicians, they sometimes influence or exacerbate the chieftaincy conflicts for electoral advantage, and they disrupt traditional neutrality and fuel factionalism. And let me just talk about one more, weak or ambiguous legal frameworks. Constitutions and chieftaincy acts or chieftaincy regulations do exist. In Ghana, we have the Chieftaincy Act, which is the activities of the chieftaincy institution, but sometimes enforcement is uneven. There are overlapping jurisdictions between customary law and formal courts, and they often prolong disputes instead of resolving them. So these are some of the causes. Now, what are the characteristics? What do they look like? There's protracted duration. Some of these disputes last for decades. There's community division. They split communities and families. And there's often spillover effects on education. I mean, if there's a fight, there's a conflict, children don't go to school. It affects trade and mobility. People cannot move as easily as they would want to. Then there's also the potential for violence. Some actually escalate into armed clashes, property destruction, and unfortunately fatalities. And then there's also legal and extra-legal pathways. What do I mean? Disputes are fought both in courts and through traditional or political maneuvering. So you're wondering, all right, we've heard about this conflict. What has it got to do with international investor communities? The challenge of chieftaincy and ethnic violence has a challenge to peace in Ghana. And for 4 reasons. First of all, security and stability risks. Chieftaincy disputes can destabilize entire districts or region. And for an investor, an unresolved conflict, it threatens an infrastructure project, workforce stability, and the supply chain. Another reason why international and investor communities should be concerned or should yes, should be concerned about chieftaincy conflicts in Ghana and indeed other African countries is that there are obstacles to development. This is because development partners may face delays or resistance in areas where chieftaincy disputes undermine local cooperation or legitimacy. Land acquisition for schools, for example, roads or businesses, they can all be obstructed when you have such conflicts. Another reason why we should be concerned as an international community is because of the legal and investment risk. Yes, every investment comes with a risk, but obviously when there's a chieftaincy dispute or a conflict, there's a heightened risk. And when land titles or leadership structures are being contested, businesses face legal uncertainty because Faction A says it's us, Faction B says it belongs to us. Who do you buy the land from? Who do you pay royalty to? This increases the cost of due diligence and can deter foreign direct investment. And let me say finally, it also has an impact on peace building and governance. Obviously, it goes without saying, for international partners who are interested in democracy, rule of law, and peace building, chieftaincy conflicts signal unresolved governance challenges, which must be addressed at both local and national levels. So in summary, I would say chieftaincy conflicts are more than traditional matters. They're governance issues, and they come with real socioeconomic and geopolitical implications. If you ignore them, it comes at a cost, not just to the communities involved, but to broader national and regional development goals. Yes.
Thank you so very much, Dr. Elizabeth. Thank you. Now, you mentioned the Baku conflict
Yes.
in your opening remarks. I want to turn to Nuhu. And Nuhu, okay, so can you tell us what is this Baku chieftaincy conflict? And what is the current state of this conflict? We also sort of would like you to engage with if there's been any attempts at resolving the conflict. Because before we started, you were telling me about the attacks to some of the community that happened yesterday, and we had fatalities. And that goes back to some of the risks that Elizabeth had identified. No.
Thank you so much, Prof, for the opportunity for us to actually share our views on the mediating chieftaincy conflict in Ghana, in Africa, with a particular focus on the Boko issue in Ghana. So in the case of the Boko chieftaincy conflict, it has a historical antecedent that informed the current state of it. So in order for us to appreciate what happened, what I would say initially is that the whole thing started, the conflict itself began in 1957 when the Boko two Rava chiefs were enskinned, and it sparked the conflict. But before even the two Rava enskillment in June 1957, what happened was that beginning 1721, the Najuri of Mamprugu started enskinning chiefs in Boko. And it's surrounding about 6 different communities that he was enskinning chiefs. Now, there were other communities who do not actually have chiefs in those places. So when the British came, they arrived there in 1909, and they wanted to introduce what we call indirect rule system. So in the various areas where the Nigeria had already enskin chiefs, they didn't have any problem. They could rule through them. But the other communities, there were no chiefs. So they got there and they decided to appoint individuals that they felt could be, chiefs, who were described in the local context as Tindana, means it's being misinterpreted to mean landowner. But it has, contested meanings. But when they came and then appointed these individuals as the chiefs, before they started their indirect rule in 1932, they thought that it was good for them to have someone who is the head or the leader of all the chiefs there, so that if they want to have any interaction, they will interact with the leader, and he can then descend down to the other sub chiefs below him. So in doing so, they brought in, and these were 2 different. The Nigerian enskin chiefs were Mamprusis. Now the chiefs that the British appointed were Kusasis. in the various areas that they were not chiefs. Now, these two chiefs, they then pick one from the Kusasis, one from the Mamprusis to contest, as the head chief. So they unanimously, the chiefs themselves said, no, we would rather go alongside with the Mamprusi chief in Boku. So indeed, the Boku chief was selected as the head chief. Now, in 1957, when the head chief died, that was when again we had just gained independence. So we had our independence in 1957, March, and in June was when the Nigeria did the enskinment because the existing or the reigning chief had passed away. So a new chief was to be enskinned. So on the 6th of June 1957, a new chief was enskinned in Nalergo at the Nigerian palace. Now, when the chief was enskinned, the following day, the other group also declared another person from the Kusasi faction as a chief. So that was when the rivalry started. So in terms of intervention, yes. So immediately it happened. The Nigeria State Council, they brought an action against the Kusasi chief before the magistrate court. But the government then also established the Opoku Afari Committee to investigate into the matter. So the investigating proceeded and they gave their verdict in favor of the Kusasis. Now, the Kusasi, the Mamprusi ventilated their grievance before the High Court. The High Court overturned the government decision in favor of the Mamprusis. And government appealed against the decision before the Court of Appeal. And the Court of Appeal, again, restored the government position in the matter in favor of the Kusasis. So the Kusasis ruled the area until 1966 when Kwame Nkrumah was overthrown. So the new government came in and they came out with a new decree and restored the Mamprusi chief back. Now, the Mamprusi continued to rule the place until 1979, when Abu Grago, the Kusasi chief, again said he's the chief again. So when he rose up again and said he was a chief, the Mamprusi took him to the High Court, and the High Court, ruled against him and said he's banned to be the chief. He's not a chief. And he again brought the action before the Judicial Council of the National House of Chiefs, which is mandated by the Constitution of Ghana to actually mediate or handle chieftaincy disputes. So the matter was before the National House of Chiefs Judicial Committee, and again in 1983 they gave their ruling in May against him against the Kusasi chief. Now in August, the Kusasi chief passed away, but before that he was declared as a commoner and not recognized as a chief in May 1983. So when the government then, which was also a military government under Rawlings, they came out with a new decree in December 1983, restoring the Kusasi chief back to the throne, and this enskinned or distooled or removed their recognition to the Mamprusi chief, and that set in another war or another conflict between the parties until 2003, when the 2003 when there was a change of government from the National Democratic Congress or the NDC, which because the military government metamorphoses into the National Democratic Congress, and they then continue to govern the country until 2001 when they handed over power to the new party. The National Democratic the New Patriotic Party. So when the New Patriotic Party came into power, which the Mamprusi seems to align to, they also went to court to now challenge the law that was passed by the military government in 1983 to give recognition to the Kusasi as a chief, the Kusasi Abu Grago Azoka as a chief. Now, when they went to the Supreme Court, interestingly, in 1996, there was an appeal. In other words, the law was repealed. The law that brought the Kusasi back to the throne was repealed in 1996, unknown to the Mamprusis. So when the Mamprusi got to know that, they filed a case before it came to their attention that the law had already been repealed. And the action was contesting the constitutionality of that particular PNDC law 75. So in the course of that, when they realized that they filed a discontinuation of the suit before the Supreme Court, and the Supreme Court granted the request, but without liberty to apply under challenging that same law. And traditionally, once you happen to a chief dies, until the funeral is performed, you cannot enskin a new chief. So the Mamprisi thought that, oh, well, once this law is no more there, that was the law that banned the Mamprisi from enskinning a chief. Then we will go ahead and now we'll perform our funeral and do our enskinment. But effort at performing the funeral could not materialize until 2021. Later part of 2021, in December, the last days of the month, was when they were able to perform the funeral. And government was not pleased with it, and the government actually arrested those who actually supported in performing the funeral. And they went to court, and they were eventually discharged because they could not actually pinpoint what law they violated. So by virtue of that, they were discharged. And when they were discharged, later in 2023, then the Mamprisi now did their enskinment. Following the enskinment, then the conflict again resurrected, and it became brutal. And since then, what is happening is that there has been attack and counter-attack, and government has to engage Otumfuo Asantehene, who is one of the prominent chief in the country, and in fact, widely respected. He has been engaged to now mediate between the parties, and the mediation is currently ongoing. So there has been a number of state interventions, but over the past, the intervention will go in favor of one party or the other. And that has been the trend of things until so now the issue is being mediated, but the certain or the disturbing aspect of it is that while the mediation is ongoing, the parties are attacking each other so the Kusasi will attack the Mamprisi will also counter or, retaliate. So that, started, and it became so, serious beginning in October last year, October 2024, was when the Mamprisi enskined Boku Naba, then went back to Boku, and then the whole thing, in fact, once he was enskined, the government, as you mentioned this, the government issued an arrest warrant against the newly enskined chief by the Nayuri. So, and the matter was contested before the High Court. The High Court insisted that they rule in favor of the arrest warrant. Now, the Mamprisi again challenged that before the Court of Appeal, and the Court of Appeal in October 2024 set aside the arrest warrant and declared it as an illegal and for that matter, null and void, arrest warrant. And by virtue of that,
Doctor, I'm sorry to interrupt, but I suppose from what you have described so far, we can see the tension between the customary processes and the modern, if you like, or the state formal processes, and the shift in power. Because obviously there's, as Elizabeth had reminded us, a part of the problems are influence and interference by the political angle, the government. And incidentally, it appears that that interference extends to the courts as well. And so with the conflicting, if you like, judge decisions and coming out of the courts, the question then becomes, do you think that asking the Otumfuo, is that the person, the chief's name, asking the Otumfuo to mediate, do you think that that might actually help in resolving for good the dispute?
Thank you so much for that important question. The Otumfuo, we see prospects of the Otumfuo mediation bringing bringing the conflict to an end. And why we think so is that this is an opportunity for the parties to themselves. Once it's mediation, the parties themselves will propose what is acceptable to them, and there will be the opportunity for them to also what they can compromise and what will be accepted to them. So each party will bring their own views into a table, and based on what is being agreed upon. So the mediator is not to force any decision on any party, but is to appeal to them to give what they can concede, in other words, concessions, leading to the resolution of what they matter. And our argument is that, yes, if this is a very good prospect, I mean, it has a lot of prospect to actually bring the issue to a finality. And why the previous ones failed? Because at any time a decision is given, it appears the contesting claims of one of the parties is put aside. So while the decision would now favor one party, and this is what has culminated to the resistance that people have always mounted against any decision that they face. But this one is where the parties themselves are involved, and they themselves will come out with their suggestions as to how the matter is resolved. And we believe that when that happens, the matter can come, we can get a final resolution to the matter.
Okay. Elizabeth, I'm going to pull you back in. I know that Michael has his hands up, but we'll take questions shortly. But I want to quickly bring Elizabeth in. And Elizabeth, can you just sort of sketch out for us traditional mediation, customary arbitration? What are these processes? How do they function? And how are these processes, if you like, different from modern forms of mediation and arbitration, what most people in the webinar would be aware of?
Okay. So dispute resolution in Africa operates across two broad systems, and we've said it already in different ways this afternoon. Customary dispute resolution processes and modern, or some people also refer them as statutory. Both systems aim to resolve conflict, but they differ significantly in principles, procedures, and outcomes. In many local contexts, customary approaches are still the preferred or more effective choice. So let's just look at both of them. First of all, let's look at legal basis and formality. Modern dispute resolution processes like litigation, mediation, and arbitration are governed by formal laws, statutes, procedural laws. On the other hand, customary dispute resolution is grounded in unwritten cultural norms, ancestral practices, and community values. This is what we've done over the years. This is what we are comfortable with. This is what has been handed over. It works for us. We'll keep on doing it. The second key difference is the nature of the decision maker. In the modern system, disputes are resolved by trained professionals, a judge, or an accredited mediator. In customary systems, you have respected elders, chiefs, or lineage heads. They are the neutral parties who are selected for their wisdom and social legitimacy rather than formal qualifications. The third key difference will be the process and procedure. Now, the modern dispute resolution system, they're often adversarial. That's how they're meant to be. There's a winner, there's a loser. That's how it works. It's time consuming and it's rigid. And there's an emphasis on legal precedents and evidence. That is what we've been taught. That is how we resolve conflicts. But the customary processes are typically conciliatory and they're informal and they're dialogue-based. Let's hear you. What do you think? This is what we think. And they focus on restoring relationships rather than assigning fault. That is the focus. And another key difference is the enforceability of outcomes. Court decisions are legally binding and they are enforced by state mechanisms. But customary rulings are accepted because of the communal respect and shared norms. The key word is accepted. Now, compliance doesn't come from the threat of sanctions, no, but from social cohesion. And of course, there's a fear of ostracism. And then finally, language and accessibility, which is a key difference. Customary systems often use local languages and cultural references, so they are more accessible to rural populations. But formal courts, we know what happens there. Sometimes it can come across as being alienating, expensive, and linguistically inaccessible to many ordinary people. This is the language we speak. Of course, they'll have interpreters, but sometimes it's not really what they want. So why are we saying that customary processes are more accepted or more effective in some scenarios? First of all, like I've already inferred, cultural relevance and legitimacy. Now, the customary processes reflect local values, traditions, and the worldviews. This is what our community holds in high esteem. This is what we place a premium on. As such, the parties are more likely to trust the process and accept its outcome, even without legal enforcement. This is how it's always been done. And that is what we want. This is the unity. This is how we work as a community. They are more likely to go along. The second reason why customary processes are more accepted or more effective is the restorative focus. Rather than punishing or blaming, customary processes aim to, as it were, restore harmony within the community. So when it comes to chieftaincy and land disputes, that is very, very important because social relationships continue long after the dispute is resolved. And if Nuhu must have mentioned in his, when he was speaking, these two contesting factions, the Bokofa, most of them, they are related. Most of them have intermarried. So it's in our own interest, or it's a hope that we'll be able to resolve this conflict along these lines because the relationship need to continue. Now, another reason why this customary processes are more effective is the timeliness and cost, like I've already referred to. Customary dispute resolutions, they tend to be more faster and cost effective than formal litigation. And for communities with very limited resource, this is a major advantage. And then, of course, there's a flexibility and adaptability. Now, customary systems, they are not bound by rigid rules of procedure. They allow room for compromise, apology, ritual cleansing, or symbolic gestures that modern systems overlook. I mean, there's no place for apology in the modern court system, and then, you apologize, you move on. No, if there's a sanction, it has to be applied. And then finally, the community ownership of outcomes. Because the community is often involved in the process, whether as witnesses, supporters, or observers, the resolution feels inclusive and collectively owned, and that enhances long-term peace. So modern and customary, modern dispute resolution systems and customary dispute resolution systems, each they have their own strengths. But the key is to recognize when and how to engage them appropriately. In many African contexts, we believe that, especially when it has to do with chieftaincy or land, customary dispute resolution systems may offer more culturally grounded, durable, and widely accepted outcomes, which is what we need, especially for a conflict like this.
Okay, thank you very much for setting out all of those details and the differences and the I think advantages of those of the customary dispute resolution processes. No, if we apply all that Elizabeth has said to this Baku problem, how would this work such that it will bring to what, let me say, Elizabeth says, community ownership of the process and that it's restorative. And so how would that help? Because clearly it appears that's what those communities need, at least so that they can stop killing each other.
Yeah, so like Elizabeth rightly pointed out, the customary mediation is a right route for us to actually achieve a sustainable resolution of the dispute. And indeed, the Constitution stipulates various pathways through which chieftaincy disputes could be resolved. The initial issue is for it to be submitted before the Regional House of Chiefs, and the Judicial Committee of the Regional House of Chiefs will deal with it. Then it will proceed to if you are not satisfied, you can make an appeal to the National House of Chiefs, and then again, they will constitute the Judicial Committee again to look into it. If that fails, then you can then proceed or make an appeal to the Supreme Court, which has a final and binding determination on such matters. But going through that route will not be helpful for us because, has proved in a number of instances not to have actually produced sustainable peace to a number of communities. So by virtue of that, the current route that the government actually proposed and the parties bought into it by submitting themselves before the O2 for mediation will, as Elizabeth pointed out, will actually ensure that by the close of the day, if the parties themselves contribute in, suggesting options of how the matter will be addressed, and that is accepted, we have the conviction that, or strong conviction that, once they actually propose it, they will own it, as Elizabeth pointed out, and once they own it, they themselves will actually ensure that it, they abide by it. So that is why we think that the mediation will actually potentially bring us a possible resolution of the dispute.
Yeah. Thank you. So both of you sort of strongly believe that because customary mediation, let me use that for now, that phrase, the outcome would depend on acceptance by the disputants. And so if they accept it, then they will comply with it. I think that's would that be a fair summary of the view both of you share?
Yes, that is.
Yes. Okay. Prof, yes, that's the fact. So if they happen to mediate and come to a conclusion and they themselves agree to it, once they themselves agree to it, then it's likely to actually work in bringing an end to the conflict. However, a number of disturbing incidents seems to be ongoing alongside the mediation, which do not seem to be very helpful to the matter. And for that matter, if we really mean business, both government and the parties themselves, and in fact, the mediator in this context, then certain, measures have to be taken urgently to ensure that those ones are dealt with, those concerns are dealt with to, ensure that the parties buy into whatever outcome they themselves will actually, propose by the close of the day.
Okay. So thank you so very much. It is really fascinating. So we've sort of heard the nature of these disputes, how important chiefs are, and we most African communities will say that it's not status based, but it is heavily status based, from what you have both told us, and why this is really important. It was interesting noting when you were giving us the history that in 1983, the chief was no longer recognized as chief, but as a commoner. And that's is as good as killing him. I mean, it's like he's dead. He's not. He doesn't exist anymore. Yeah. And that goes to show how important people take these various roles. And for those of you who are very I don't know whether it's Gen Zs or very modern people, you might be thinking that, oh, this is so 1940 something or before pre-colonial periods. But we have young, well-educated people who actually vie for these roles. They are very much interested in becoming chiefs and becoming first-class chiefs, kings, and all of that, which means there must be some benefits to these roles and status, I guess, to these roles. But anyway, before we carry on, I'm going to, I think Nuhu and Elizabeth are happy to take questions. So we're going to pause and we'll take questions. There are various ways you can ask questions. Michael, I'll start with you because you had raised your hand. If you want, you can raise your hand. If you're asking a question, please go straight to the question. If you want to type in the chat, that is fine. Michael.
Well, firstly, thank you very much. I think that's absolutely fascinating to hear that. And I was both aware of parallels with mediation, but also with complexity of peerage decisions, which are decided by the House of Lords with its own kind of arcane procedure. My question is, I'd really like to understand this a bit more. From what you've described, it would seem to me, and please correct me if I'm wrong, that it's more like a process of customary arbitration. I mean, what you're referring to, the kind of language you're using of making rulings and appeals, doesn't, to me, kind of sound like mediation, because mediation would generally be seen as resting on the parties both having autonomy and the parties making their own decision. So I mean, I wonder if you could fill me in a little bit on that. We had a very interesting seminar recently at SADRAC, thinking about mediation in Singapore, where we learned that many of the traditional values of impartiality, confidentiality, and voluntariness are slightly different in that context. I wonder if you could both explain a little bit about where this falls in terms of that area between arbitration, adjudication, where the third party has the decision-making role, and mediation, where the role really is of the parties of making their own decisions.
Thank you very much, Michael. So we have two more questions. I would suggest that we take those, and then so that you can take. Michael needs clarity with the different types. Thank you very much, Michael. Kevin?
Great, thank you, Professor. Yeah, thank you, Elizabeth. Thank you.
Kevin, what's happening to your? We can hardly hear you.
Oh, can you? How is?
Yeah, we can hear you. We can hear you now.
Can you hear me now? Okay.
Yes, we can hear you now.
Is my camera on? Can you see me?
Yes, we can also see you.
Okay, great.
Yes.
Yeah, my question is how would you describe, or what are the sort of overriding compelling incentives for both sides to participate in customary mediation versus the continuation of this quite devastating situation?
Okay.
So what are the overriding, you briefly mentioned relationship, I was wondering what are the overriding compelling incentives for both sides to participate to the table?
Okay, so overriding incentives, why should they participate? Okay, thank you very much, Kevin. We then have Isaac.
Thank you, Dr. Nuhu, Yidana, and Dr. Emilia, Onyema for putting this together.
And Dr. Elizabeth.
Yeah, Dr. Elizabeth.
You were thinking of her name. Yes.
Well, intentional. Yeah. So as I listened to both presentations, what came to mind was Jennifer Jones, American Journal of Sociology paper in 2020 about theorizing racial status and intergroup relations. And in that paper, she sort of proposes a theory that she calls shared racial status, which argues that shared racial status sort of brings racial groups closely together through sustained positive contact and the development of a perceived, collective external threat. I think both panelists have argued that the Kozasis, and the Mampusis have intermarried and thus have a sense of shared ethnic status, but we've seen so much conflict, right? In contrast, in places like Chieftaincy, which I believe Dr. Yidana knows much about, paramount chiefs often originate from, Mampusi lineage, wherein, these Mampusis have similarly intermarried with Chieftaincies or the natives, laying the foundation for a similar sense of shared ethnic status. Here, Mampusi-related rule is accepted. And so I'm thinking about how can we possibly explain this sort of spatial variation in intergroup relations in places in the Upper East region, where on the one hand, Mampusi sort of related rule is accepted, such as Chieftaincy, but on the other hand, such as, the Boko area, Mampusi related rule is sort of challenged.
Great, thank you very much. One more, and so we can then pull all of this. We'll take this first round of questions. Mark, you wanted to ask a question, then we'll come to answer, please. Mark.
Thank you so much, Professor. Thank you so much once more, Dr. Izac-Hassan and Dr. Yidana, for that excellent presentation. I just have some questions with regards to the process of resolving the dispute. So I know Dr. Izac-Hassan spoke about the community and them having a sense of togetherness and them wanting to sort of enforce the outcome of what you're referring to as a mediation process. So from your perspective and your research, is that the only sort of way that they can agree, given that this is such a prolonged dispute that spans through the courts and now through the mediation? So is it going to have to take them coming together to agree the outcome of the mediation? And in your opinion, do you think the litigation, because also Dr. Izac-Hassan spoke about this, the fact that they didn't like, or the fact that other outside or different systems outside of the customary ways of resolving the dispute may not really settle well within this community? So do you feel that the litigation, because this has been through court for a very long time, has that also spurred the sort of added fuel to the dispute between the two communities? And that's basically it. Thank you so much.
Thank you so very much. The acrimony that comes with litigation. So, doctors, please go ahead, and we have a couple more in the chat, but please go on. If we answer this lot, Dr. Yidana, you're on mute.
Yeah, so I think the questions are interlinked, and the incentive to mediate and the idea of Mamprusy rule being accepted in Talensi, or Mamprusy being accepted in Talensi and not being accepted in Boku. Let me deal with those ones first. I mean, I see them to be interlinked. So with that, what seems to be the case in terms of Mike, your question on the over, sorry, I was that Mike. Okay, so the issue is this: there are commonalities in terms of intermarriages between Mamprusy and Kusasis over the years. As I said earlier, Mamprusy in Boku started in 1721. 1721 to the time the British actually arrived there, that's 186 years. So this 186 years period was enough for us to actually have, intermarriages across. Now, when it comes to even a significant group of the today Kusasis that we know from the historical records, what it tells us is that when the Mamprusy chiefs even came to settle in Boku and Binduri, Sinbaga, in those communities, they came with a group of people they called the Bandurisi, and those ones, majority of them today now call themselves Kusasis. So with that, they are one. Now, the other Kusasis, which the historical records indicate that they migrated from Bengu, Zauga, and Ayuga presently in Burkina Faso to their present location. When they also came, they link up with the historical records indicate that they link up with the Nigeria for recognition. So with that, there is that commonalities between them. There are historical ties, strong historical ties between the various today's factions. And the issue seems to be politically motivated because the those who led in appointing the first Kusasi chief was in the Convention People's Party, the Common Nkrumah's Party. And there was also an opposing political party, Northern People's Party, which the Nigeria seems to have aligned himself with. And the then Nigeria seems to have aligned himself with from the historical records. And Kwame Nkrumah was not pleased with him. So what he could do was that he made a statement that, he will try and cut him into his sizes. So we saw that manifested subsequently when in 1960 he created a region. The entire northern sector was called Northern. Was one. So he came and created the upper region and cut out the Mamprusy to be part of the northern region, and the upper region then comprises the current upper west and upper east. Now, in terms of Mamprusy being accepted in Talensi area, there hasn't. In fact, that was also tried because Kwame Nkrumah used the youth there as well from the historical records. If that is really true, he used the youth because the youth supported Kwame Nkrumah's vision, but the chiefs who were linked to the Nigeria supported the Nigeria's alignment with the Northern People's Party then, which is now metamorphosed, which now link up to the current political party known as the New Patriotic Party. So now they just left power early this year and gave power to NDC. So now the issue is that in terms of their intermarriages, one would have think that is a basis. I think that is one of the incentive why they should agree for a resolution of the conflict. Two, beyond the intermarriages, a good number of the present-day Kusasis are also even linked to the Mamprises. So there is that commonalities between the two parties, of which they should find basic grounds to actually, have the conflict resolved in their own interest. That's what I'll answer. I'll say to that part. So, Elizabeth, do you want to come in to the other questions?
Thank you very much, Dr. Elizabeth, please.
Yes. Okay, thank you very much. So I'll pick up from where you left off, talking about overriding compelling incentives for both sides, and I'll touch on the clarity on different types of customary arbitration. Right. So at the end of the day, this conflict needs to be resolved, not just for investors' sake, but life needs to go on. Like Nuhu must have said earlier, he did say, property has been destroyed, lives have been lost. And that is something which is it mars Ghana's democracy. We need to do something about it. The conflict needs to be resolved, and it can be resolved either two ways. It's either we litigate it or we find a way for the parties to build a consensus and come up with a resolution. And we tried to say that in our proposition has been that litigation cannot resolve this dispute effectively. Why? Because litigation has its shortcomings. I'll just pick up a few. It is adversarial. There's nothing like win-win in litigation. No, there's at the end of the day, there's the vanquished, and there's also the person who's won. There's the winner. Winner takes all. That's how litigation works. But we're saying that the nature of this dispute is an ethnic dispute. We cannot have such an outcome. Also, there's delay and cost. I'm sure most of you know about delays in our court system. Cases can drag on for years, and chieftaincy issues do drag on for years. That's not right. Another reason why we think litigation will not give us the finality we want is that the judicial system or the judge has
Elizabeth is actually in the UK and her internet is playing up. Just to give people comfort. Elizabeth, sorry, we're losing you. Your internet is playing up.
Oh, hello. Can you hear me?
We can hear you now. Please go on.
Okay. Thank you. So I was just trying to emphasize or to draw attention to the fact why litigation will not work or will not be effective in ending this conflict. I've tried to say that litigation is adversarial, there's a delay, and there's a limited understanding of customary context by the judges, and also there's a poor record. We have a poor record of finality in chieftaincy cases in Ghana. So we believe that customary dispute resolution is a better option. Why? It preserves social relationships. And I'm just rehashing what I've already said earlier. And it also ensures that traditional authority and processes are maintained. And most importantly, when it's successful, it produces clarity on the different types of customary arbitration. I think that was the first question which came. Right. Now, in Ghana, we have the ADR Act, which was passed in 2010. Yes. So that's the Alternative Dispute Resolution Act, which outlines all forms of dispute resolution outside the formal justice system. So you have systems like you have the arbitration, mediation, customary arbitration, and you have negotiated settlement. Now, from what we've been talking about this afternoon, we may have used the term mediation, but I think when we started, Professor Emilia said customary mediation, so to speak. And then we've also said customary dispute resolution. So what we've been talking about has strictly been customary dispute resolution and not mediation, properly so-called as we know it. Now, under Ghana's laws, Ghana is a pluralist state. So it means that we have formal laws as promulgated by the Constitution and other statutes, and we also have our customary laws, which the Constitution does recognize. And one of the provisions it recognizes is that people are entitled to have the dispute resolved customarily. So this is what we call customary arbitration under the laws of Ghana. And this is where we have, like I've sought to describe, we have the chiefs, elders, they bring both parties, or both parties appear before them, they presented what they had. So when we use the word custom, if we've used the word mediation whilst we're speaking, that is what we're talking to. That is slightly different from mediation as a modern dispute resolution process, which you might be familiar with, Dr. Bartlett. So
maybe
I hope
to
I've
just
answered
sort
the
of,
question.
thank you very much, Elizabeth. So maybe to pick up on a couple of points here. And just going back to the point that Michael had made and mediation as we were, when we had the webinar from Singapore. In most African communities, dispute resolution processes are slightly different from the way we would describe the modern processes. So one of the things, for example, with customary arbitration is that, yes, it is adjudicative, but even customary mediation is adjudicative in the sense that you have people, and they're usually not neutral. They're people that both sides trust. That's the key point. That you have to make you make your case to them, and they decide. Now, when we say, well, when Elizabeth was talking about accepting that decision, I think that is really important, because in some communities, certainly in Nigeria, part of the reason or the differences with customary arbitration is that where the parties do not accept that decision, then it's not a decision effectively, which will be contrary to what modern forms of arbitration, the way we would describe modern forms of arbitration. So maybe using those descriptors might be incorrect, and maybe that's why we were thinking of customary dispute resolution processes, which have a scale, if you like. I think that might deal with some of those concerns that Michael raised. Michael, did you want to come back? You're mute.
Sorry, only very, very briefly. Thank you. I mean, that's really, really helpful. Could you just clarify for me who actually is mediating this? Is the mediator a paramount chief, or is it the regional house of chiefs who was mediating it? Just the person of the mediator.
One word, so that we can move on to other questions. Who's mediating this? The Otumfuo, is it?
The Otumfuo, he's one of the paramount chiefs in Ghana. And the government, there was an earlier case similar, and government constituted what they call three eminent chiefs. And he was the chairman of that three eminent chiefs. And they've succeeded in bringing peace to different factions. So he's the one who is being engaged now. And during that three eminent chiefs, one of the current parties to the case was one of the eminent chiefs. So he could not be part. So that's why they appointed him as the sole mediator in this particular instance.
And really, if you look at the practice, what we have within the ECOWAS, for example, that's what the heads of government and heads of states and governments of ECOWAS countries, that's the way they proceed. Certainly having, when we had our former president, Obasanjo, jumping around the continent, trying to resolve various disputes, and they're quite keen on those. There is we have a couple of questions in the chat and in the Q&A. And so we have Mercedes Rosello, who said, are customary dispute settlement actors obligated to take into account existing elements of national law in their decision making? So just like arbitrators would apply the law, do mediators, customary dispute resolvers, do they take national law into consideration?
Good. So thank you, Mercedes, for your question. In deciding their matter, and when the issue is resolved, indeed there is an established principles of law that customary mediation or customary arbitration or customary, any non-judicial form of dispute resolution must satisfy for it to stand. So if a party is not satisfied, it can make an appeal before a court of law, and the court will now test it against those criteria, whether those criteria have been satisfied. And one of it is voluntary submission of the issue before the mediator or the arbitrator or whatever way we use it. Then the party also not being, not demonstrating issue of being biased in any way throughout the mediation process, and also the voluntary acceptance. Voluntary submission. Not being biased, and also not being the decision being made. The decision being made without being biased in any form. Or
yes,
there are four main conditions. What are the other two, Elizabeth, if you remember them?
If I may add, I was just going to say that when it comes to enforcement of the awards, one of the things the court will look at is whether the rules of natural justice have been adhered to.
Complied, yes. So that falls within the whether you've been biased or otherwise. So if those conditions are satisfied, then the court will uphold the decision. If they were not in compliance with, then it will be a basis for the court to strike down such a decision or such an outcome. So, and indeed, that has also been recognized under the Arbitration Act 2010. That has also been, captured under that particular law. So there is a connection between the customary process of resolving disputes and that of what is being recognized as state law.
Okay, thank you very much. So we have a couple of questions in the chat regarding data on number of cases that have been litigated and settled. And Chinwe has a book called Appropriate Dispute Resolution in Comparative Perspectives, and she deals with customary dispute resolution processes in her book. And she then, the process for the Otumfor mediation, okay, so that's been answered. Isaac, did you want to come back? Because what it's sounding like is that with the interference of litigation, as Elizabeth has alluded to, in this particular dispute, that this theory of shared ethnic status might not work. I don't know. Did you want to come back? You have your hand raised, Isaac.
Yeah, but it's a different
Please.
question. I think
Okay.
Dr. Nuhu attempted to answer my question, so I'm okay with that. But
Okay.
I have a different question. So I think so. This dispute is currently being mediated by the Asante Hine or the Asante King, which is the Otumfor. But there is a certain history to the Otumfor being, appointed by the government to mediate this dispute, because I think the first term of the previous government between 2017 and 2020, the Otumfor played a pivotal role in mediating the Yendi conflict. Nonetheless, the Yendi chieftaincy dispute was between two families, not two ethnic groups.
Yeah.
And so some have argued that perhaps, the Boko conflict, which is between two ethnic groups, presents a peculiar challenge, to the mediation being successful, as the two parties appear to have taken entrenched position. So, Dr. Nuhu, how do you see the peculiar nature of the Boko conflict presenting a particular challenge, to the mediation?
Thank you so much for that. Indeed, there is some slight differences between the background, as far as the background of the cases, the conflicts are concerned, as you rightly pointed out. But we think that the issue needs to be resolved. And if it has to be resolved, we have to go through one of the processes available to us to actually get the matter resolved. And considering the fact that the issue is a very sensitive and complex nature, what I'm foreseeing is that if we resort to the adjudication through the National House of Chiefs, indeed, the National House of Chiefs gave its ruling in 1983, but that has not really worked out. Again, we have a number of other chieftaincy conflicts which have also been determined by the Supreme Court, and the outcome enforcing that has become a problem. So that's why we think that, given the fact that the parties themselves have agreed to submit themselves before Otumfor, is a good start for us. And we believe that once they are ready to they want the issue to be resolved. That's why they've submitted themselves before Otumfor for mediation. So if Otumfor also follow due process by, buying in their confidence and trust in him, of which they have, we have the potential of having the matter being mediated and resolved. In terms of the issue between the Mamprisus and Kusasis, if you go back to the historical records, from what most of the historical records actually indicate, we believe that if they are going to court, the matter will be determined in favor of one party. And the point is, when it comes to enforcement, it will become another challenge, just like the other decisions being rendered, and there hasn't been any finality to those matters. So we believe that the mediation is the best option, subject to a number of other things that need to be satisfied, which we'll comment on that if permission is granted. Yeah.
Thank you so very much. We have completely run out of time, and we still have questions coming in the chat. It's obvious that people are very much interested in this fascinating topic, which I have learned a lot, because I have no clue what Otumfo is and all of that, and I've learned so much just preparing for this webinar. So a huge thank you to Nuhu and to Elizabeth for sharing their research with us. Nuhu, did you want to say something?
Yes, Prof, I want to add one important suggestion we have, as far as, indeed we have a number of suggestions, but for want of time. Yes. But one of the key things that need to actually be taken into consideration, there has been a ceasefire of the ongoing attacks. In May, a community was attacked and 12 houses were burned. Yesterday, as I just spoke, a truck was intercepted and 3 people were killed. So what needs to be done is for the mediator, in collaboration with government, to get the parties to actually sign a ceasefire agreement. And they should involve the youth leaders as well, to have that, if they have that, a ceasefire agreement signed, while the mediation progresses and we see how the outcome will be, it will be very helpful to actually ensure that the matter is resolved and everybody will survive, to witness the beauty of unity among the parties. That's our suggestion.
Okay, which is very, very helpful. Elizabeth, did you have any last minute comments?
Yes, thank you so much. So I just 2 points to add to what Nuhu has said. That as part of making sure that this process is as successful as it can be, it will be a good idea for the panel to plan, not just the panel, but the government as well, to plan for a post-mediation implementation and monitoring. Because after an agreement has been reached, we need mechanisms to be put in place to implement the outcomes, monitor compliance, and resolve any emerging issues. Because every peace agreement without a follow-up is unlikely to hold. And also, most importantly, I'm hoping that, or we are proposing that government should back the process without political interference. The government should provide logistical and legal support, such as security funding and transitional arrangements, but must avoid politicizing the process. Government neutrality is critical to ensure that trust is held and maintained by the people. So those are the proposals I'd like to add to what Nuhu said.
Okay, so I would just suggest that for the research, it might be useful for both of you to also consider the Gakaka system, that the restorative justice process that they had following the Rwandan 1994 genocide, to just see whether there are things from that that you may suggest. And then maybe the South African Truth and Reconciliation Commission as well, to just sort of look at those. You might find interesting synergies or processes that you may want to also recommend. You may also want to recommend in your paper. I noticed that we have our deputy director who is attending. Usually we just sort of, okay, sorry, I'm going to have to mute people now. We usually would ask, I haven't told him, but usually when we have a member of our management committee on, they get to say the last words. Stephen? I thought as
no,
okay.
Emilia, so, I'm sorry. I'm in an outside spot. So all I can say is this was really fascinating, and it introduced me to something that I did not know about, and the level of detail and the interesting discussion was exactly why we have these events. And so I'm really thrilled that we did this, and I'm glad we have a good recording of it. And I'm looking forward to other people being able to see this because I think it was fascinating, and I really thank our speakers.
Thank you so very much. So, speakers, a huge thank you. Please thank our speakers on behalf of the center. Our next and the last webinar for this academic year is on the 23rd of July, which is in 2 weeks' time. And it's going to be on looking at the reforms of investment treaty standards and procedures. And we will be welcoming an academic, Fahira, and it will be moderated by Hussein Hari KC, who is also a member of our management committee. So we look forward to you joining us. It's recorded, we'll clean it up a little bit because we were chatting a lot before we started. So we'll clean it up a little bit, we'll edit, and it's going to be on YouTube if you want to go back and to listen again and learn a couple more things. Nuhu, thank you very much. Elizabeth, thank you very much. And to all our attendees, thank you so very much.